Appeals is now in session.
Good morning, everyone. Welcome to this virtual session of the Utah Court of Appeals. One of our last scheduled WebEx hearings starting next month. We will return to our courtroom and entertain oral arguments in those familiar surroundings. I say familiar, it's been about 2 years since we actually had that pleasure. But at long last, we're going to go back to that. We appreciate counsels joining us this morning, however, for this virtual argument. I am Judge Gregory K. Orm, and I'm joined today by our presiding judge, Michelle Christensen Forster, and our no longer newest judge, Ryan Tenney, one of our 2 vacancies having been filled earlier in this week, although Judge Luthi has not yet assumed his official duties, wrapping up business at his prior employment. With those preliminaries out of the way, have all counsel appeared before us virtually before? I know that Ms. Adams and Ms. Pierce have multiple times. I'm less sure about Mr. Wade.
This is my first, Your Honor.
Very good. Then, largely for your benefit, let me mention a couple of things that make this a little bit different than a proceeding in the courtroom. The panel is kind of spread out on the screen, and we're in different rooms and possibly different locations. So we don't have any ability to look left and right and see who's about to ask a question. And it's probably also hard for you to pick up on that body language. So it's been our custom, if one of the judges has a question, to just put their hand up. And you don't have to stop mid-word, but probably at, if not the end of that sentence, the end of the paragraph you're on, pause your argument to come to our question. As you know, very often it's the judge's questions that are the most important part of oral argument, getting those answered to the judge's satisfaction before moving on. It's been a while since we've had any significant technical difficulties, but if we find that somebody loses their internet connection or their video or whatever, we're very forgiving about all of that. Put additional time on the clock, rewind figuratively to hear some part of an argument that we might have missed, etc. The one mistake we do continue to make with some frequency is we forget to unmute ourselves, and you'll see some judge, this happened just yesterday, in fact, a judge yakking away, but nobody can hear the judge because they neglected to unmute. Very appropriate for you or any of us to remind one another that that seems to be the situation. The next point, and perhaps Ms. Collins covered this with you before the judges joined the party here, it's very distracting given how many faces we have on the computer, and it helps us very much to concentrate on the argument being made if the attorneys not then at the virtual podium will not only mute their mic but also stop their video so that we can focus on the attorney at the podium. And then when that attorney is done, he or she will click off the video, and the next attorney up will have our undivided attention. I'll ask my colleagues any thing that I've left out that should be mentioned. Very good. Then with that, we will excuse Ms. Pierce and Mr. Waite for the time being and entertain Ms. Adams' argument in the case of In Re HC.
Thank you, Your Honor. Emily Adams for the appellant, who's the mother in this case. This is a really interesting case. It's not something that I've seen before, where between 2 fit parents, the court decided to award permanent custody and guardianship to father. Now, I think it's important to talk about what that means. Oftentimes in child welfare cases, when we're here, we're arguing that permanent custody and guardianship should have been awarded instead of terminating parental rights. But in those cases, the court is deciding with what to do with an unfit parent. Here, everybody agreed that we have two fit parents. And permanent custody and guardianship is quite
Can I
extreme.
just ask you a question about that? I mean, the parental presumption was rebutted for both mom and dad. Mom with the finding of the neglect and dad with the dependency finding. So is it accurate to describe them both as fit parents?
Yes.
Aren't they just competing on the same level?
Well, everybody agreed, the GAL and the state agreed at the time of the permanency hearing, and even the court agreed that mother's house was safe and that the children could return. So they were fit parents. And really, when we're talking about fitness, we're talking about the children being safe, and they were deemed safe to return. And what's interesting is when we're talking about permanent custody and guardianship, it's important to look at its code. It's 80-1-102, which is it's all the definitions of custody. And generally, when you have permanent custody and guardianship, you are left with residual parent rights. And those are defined under 80-1-102 as four things. So mother now can do four things. She has the responsibility to support her child, the right to consent to adoption, the right to determine the child's religious affiliation, and the right to reasonable parent time. That's it. She has no right to be involved in any of the child's school activities, to be involved in any of the medical care. None of that. She's completely excluded. Now, if this case, which more appropriately should have been dealt with in the district court as a custody battle, if father had been granted, for example, sole physical custody or sole legal custody, things would have looked a lot different. For example, mother could have petitioned to modify those custody orders, whereas a permanent custody and guardianship cannot be modified by the parent. The parent cannot petition to modify that, and it stays in place until the child is 18. When this was granted, the child was 8. And so we've got 10 years where mother is very much excluded from child's life and can't do anything about it. Whereas if this had gone to the district court, if there was a substantial material change in circumstances, mother could have sought to modify this. Also, under sole, even if father had sole custody, there are rights under it's Utah Code 30-3-33. It talks about parent time and what courts need to do to put in parent time. And the custodial parent always has an obligation to notify the non-custodial parent of all the important things that are happening in the child's life. So that the non-custodial parent has a right. It says, this is what it says in 30-3-33 sub 11. It says the non-custodial parent shall be entitled to attend and fully participate. So even if we had a sole legal, sole physical custody type of relationship in the divorce context, in the district court, mother still would have been able to be an active participant in her child's life. And in fact, throughout the divorce code in 30-3-10, it always is yes, Judge Orm.
I thought it was curious, given that the custody arrangements in place before the juvenile court became involved grew out of a divorce proceeding. I thought it was curious for the juvenile court to refer to the father in terms of being a permanent guardian. For heaven's sakes, why wouldn't that just be, I'm shifting primary custody from mother to father? They basically, a parental custody guardianship seems to be kind of wide of the mark.
Yes, Your Honor, it's extreme in this case, and that's why we're here. And I think it's important that when we look at 80-3-204, that's at the very beginning of this chapter that talks about abuse and neglect proceedings. And it says that in abuse and neglect proceedings, the juvenile court shall apply the least restrictive means and alternatives available to accomplish a compelling state interest and to prevent irretrievable destruction of family life. Here, this was not the least restrictive means. What's tricky about being in the juvenile court is once you get to the permanency hearing stage, if the court determines, if you're in section 80-3-409, which is the permanency hearing statute that we argue about thoroughly in our briefs, if the court determines that a child can't be returned home safely, then the court only has a few options, and that's in sub 4. They have to make a final determination about whether you should terminate a parent's rights or whether you need to adopt out a child or whether there's a permanent custody and guardianship relationship. There's really no other option. So you're approaching the situation with two fit parents with a sledgehammer rather than with a scalpel. And I think that's what we needed in this case, was a scalpel. We needed the district court to intervene and, delineate custody situations, but we didn't need the sledgehammer of completely removing mother in many ways, although she does have parent time, but removing her from child's life. Yes, Judge Orr.
I follow that logic. Is it clear? I guess I'm a little bit confused. And the discussion in the red brief is a little bit ambiguous about this, but it does seem to me like the juvenile court might well have said, okay, we're at a point now where we can terminate DCFS involvement. It strikes me that we probably ought to continue the current placement so the child isn't disrupted. But insofar as I have before me competing requests for changes of custody, this really ought to go back to the district court. I can see where that might have been a logical tack for Judge Bazell to take. Was she asked by your client to do that? Did your client, before we got this far along, say, Your Honor, hold on, we now have 2 fit parents. The safety concerns have passed. Your work is done here. This needs now to go back to district court should either of the parties wish to petition. Did she have a chance to be acquainted with that argument?
Yes, Your Honor. So in December 2020, before we had the dispute, so you have the adjudication hearing where the parents did the Rule 34E pleas, and they adjudicated mother as a neglecting child. And then about 2 weeks later, we had a disposition hearing, and mother asked in that disposition hearing to have child returned. Mother also filed before that hearing a document saying, please have child returned to me. Please have child returned to me. And then in March 2021 and in June 2021, we had review hearings. And in both instances, mother asked to have child returned and then also said that they were fit.
All of that seems to assume that the juvenile court is the appropriate forum. She has particular requests of the juvenile court judge. None of that seems consistent with, what are you doing messing with this? This needs to be, if anywhere, in the district court.
So if Judge Orr, if you're asking about jurisdiction, I do think that the juvenile court did have jurisdiction. If we look at Utah Code 78A-6-103 and 104, the minute that a child is adjudicated as neglected, the juvenile court has jurisdiction. And under 78A-6-104, the juvenile court has concurrent jurisdiction. It says over questions of custody, support, and parent time of a minor if the juvenile court has jurisdiction over the minor's case. So I think the juvenile court did have jurisdiction, and it could, so it had jurisdiction to enter these orders, and we're not arguing that it didn't have jurisdiction here. Between 2 fit parents, it should have handed it over to the district court. It should have said, the parents are fine, the situations have resolved. And that is what the state was arguing below. And it's very notable to me that the state is not here today, that the state has filed a letter saying that it is declining to participate in this appeal because this was a custody decision between 2 fit parents. And yes, Judge Tenney.
But if it has concurrent jurisdiction, then what is it in your view that stops it from doing what it did? And maybe my following question is going to be too general, but I just want to make sure that I've got it right in my notes. In the red brief, they've cited, I don't know what page to point to, the page numbers were not on the brief, but they cited sort of in the middle of their argument to a number of statutes within the juvenile code that require a best interest analysis at various stages. And what I understand you to be saying is that even though those statutes do contemplate a best interest analysis by the juvenile court, this juvenile court either should not have or perhaps even could not have gotten that far. And just to make sure I've got it right, what statute is it that says that the juvenile court couldn't get that far here? And what's the point at which, in your view, the district court had to stop and not go any further?
So
give me the statutes.
Mm-hmm.
Yeah.
Okay, so it's 80-3-409. So that's the permanency hearing statute. And I will say that I think that the juvenile court statutes are not drafted incredibly well. So it doesn't necessarily say that these are the 3 steps. But we see this in the termination statute where, in 80-4, which is the termination chapter, it says, here's the grounds for termination. And oh, by the way, somewhere else here in the statute, there's a note that you can't terminate unless it's in the child's best interest. That's kind of the same thing here, where I think that there's a structure. in 80-3-409, we have, if the reunification services have been ordered, everybody agrees that the court gave reunification services to mother. Then at the permanency hearing stage, the court has to decide whether the child can be safely returned. And so that's kind of like grounds in like the termination hearing, where first, before you can even get to best interest, you have to get to grounds. And so the first question before the court was, can you safely return this child? And then once you've made that, then you can go to best interest. But they never should have gone to best interest because they should have safely returned the child. I think Judge Christensen Forster has been raising your hand a lot. I'm so sorry.
I just have a question, and then you can go back to answering Judge Tenney's question about that. But there's two inquiries that need to be made in determining. First, the court has to determine whether the child can be safely returned to the parent's home, to the parent's custody, right? Without substantial detriment. And the court here found that child could be returned safely to mother's home, but that it seems to me that the court's order discusses why it would be detrimental to this child to go from father's house to mother's house. Why how do you respond to that question?
Your Honor, because the court didn't discuss detriment, it discussed best interest. Its entire discussion was where would the child be better off? And detriment is not where would the child be better off. The detriment is, would the child be harmed in this situation? And that makes a lot of sense. When a child has been removed from one home to another, the question is then, the code says that we don't terminate a parent's rights or restrict a parent's rights just because they're not a model parent. We still have constitutional rights to raise our children and to have them be in our homes with us. And so so there's a lot of instances where certainly it would be better to have children be in other homes. Honestly, if based on income and socioeconomic status, children might be better off in other places. But because we have constitutional rights to parent our child, the question becomes, can they be safe in their parents' homes? Are they safe? That's the first instance. And the district court's analysis in its order was not safety-based. It was where would the child be better off? And so that's not a detriment analysis. That's a best interest analysis. And I think that's where the court got it wrong.
That was the juvenile courts.
Yes, especially when we think about this, when I referred to it earlier, but 80-3-204, where the juvenile court is obligated to use the least restrictive means and alternatives to accomplish a compelling state interest. There was no compelling state interest here because child was not abused or harmed or in danger of any of that. So there's no reason that the state should be restricting mother's rights in such a drastic way. This was not the least restrictive means.
Judge Tenney?
That prompts my question. Is that the best statutory hook for this? I mean, and just to put the card on the table so you sort of know where I'm getting at that, what you're saying about the structure of the system resonates with me. But one of the things that I'm struggling with is to see the statute that says, here's the moment where the district court or the juvenile court has to stop. And what I understood you to be saying in response to my last question is sort of, well, if you look at it holistically, this is kind of how the pieces fit best. And I'm still wanting to see the statute that says, no, it has to stop at this moment so that we can tell the juvenile courts, you have to stop this moment. And maybe that is the best answer then, is the statute that talks about the least restrictive means, or is there a better one that's more directed to?
Yeah, I mean, we made most of our arguments under 409 kind of, because frankly, the juvenile court statutes are just a disaster. And so they're kind of, they are kind of just put together and you kind of have to figure it out. But I do think you could go under 409 or you could go under 204. And we talk about in our second argument, we talk about least restrictive means in our second argument, how the district court shouldn't have awarded permanent custody and guardianship. And so that was kind of the thrust of our second argument. So I think the court could go that way if it chose to do so. I am way over time. Judge Orr.
You are, but I have a question, and I don't want to suggest that I'm unmindful of, and you acknowledge that the juvenile courts and the district courts have concurrent jurisdiction here. Thinking of this in practical terms, if Judge Bichelle gets into this case as far as she does, and then at the last minute says, okay, now I've got two fit parents, it would be safe to return the boy to his mother. He seems to be doing well in Utah. I'm going to leave things in place, terminate this court's jurisdiction, and defer to the district court to now figure out permanent custody. I think if I'm the district court judge in that situation, I'm going to think, what the heck? I haven't looked at this case in 5 years. I never even really looked into the fitness of parents because I had a stipulated custody arrangement. Why do I pick this up now and try and figure it out? Judge Bichelle has been micromanaging this for a couple years now, has moved custody. She's taken testimony from therapists, school teachers, parents, step-parents, grandparents. Why am I, as a Johnny-come-lately, expected to somehow sort this all out? I mean, it seems efficient and prudent for her to just see it through if it could be done legally. Would you address that range of practical concerns?
Yes. Well, the district court is set up to do this exact thing. I mean, we have commissioners who can, look at child custody. They're very experienced in it. I think the tricky part about leaving it in the juvenile court is, first off, you don't have a neutral custody evaluation that's done. You've got a GAL that never visited the child, never visited Utah, never visited Florida. We don't have any neutral professional assessment of the quality of the homes. And I think that's a tricky thing. And I think that's really important. That's why we see custody evaluations all the time in district court custody cases. When you have two fit parents, we need a neutral professional who can come in and say, which is the best home for these kids to stay in. Secondly, if we look under 409, once you get 80-3-409, if you get to a permanency hearing stage and you can't return the children to the parents, the way that I read the statute under subsection 4 is that if you decide you can't return the child to the parents, then you have to make a final determination regarding whether you're going to terminate a parent's rights, go for adoption, or do a permanent custody and guardianship. It seems to me that the juvenile court's options are very, very limited, and they can't approach these types of cases with a scalpel. They have to do sledgehammer. Either you're going to lose all your rights or you're going to lose the vast majority of your rights. Those are the options that are available to the juvenile court. What this court needed to do was instead, approach it like the district court would and do a parenting plan. Maybe, there's a presumption of joint legal custody, kind of allow the mother to still be involved in the child's life. Whereas, the juvenile court doesn't really have those options available to it. Yes, Judge Christensen Forster.
I wanted to ask you about the notion here that was raised by Mr. Waite and the guardian ad litem, that the permanency statute does not compel a return to custody. You seem to be arguing that it does, right? As long as there is a finding or some sort of, decision that the child can be safely returned to the parent, that compels that action. But the juvenile court can change the permanency goal at any time, right? Before the final permanency decision. And, after adjudication of neglect or neglect here, the court gets to make any disposition that's in the best interest of the child. So I'm having trouble reconciling those two concepts, right? If the court gets to make any dispositional order that's in the best interest of the child, why does that compel a return to a parent once, at the permanency phase?
So I think that the state and the GAL, Mr. Waite and the GAL are correct that the permanency statute doesn't compel the return of the child, but the court needs to consider that in its analysis, and it didn't here. And that's the problem. And I think that we have to read these permanency statutes along with I'm going to keep on going back to 80-3-204, the least restrictive means. And yes, the court can enter any order it needs to in the child's best interest, but it also has to consider that these parents have constitutional rights and they are obligated to use the least restrictive means to ensure a compelling state interest. And once everybody agreed that these parents were fit, there was absolutely no compelling state interest to restrict mothers' rights in such a drastic way. Unless the court has any other questions, I ask this for reverse.
Thank you very much. We appreciate that. We'll see you in a few minutes for rebuttal, and we'll hear now from the guardian ad litem.
Thank you very much. Martha Pierce, attorney guardian ad litem for the minor child. Ms. Adams is arguing the standard that applies prior to adjudication. She keeps going back to 80-3-204, and that's the standard that the court applies prior to adjudication. And every time she says two fit parents, I had to flinch, because the juvenile court cannot have jurisdiction over two fit parents. So to the extent the word fit was used at the permanency hearing, that was very loosely used, because so long as the juvenile court has jurisdiction, the presumption of fitness has been rebutted, and the statute requires that all dispositional decisions be made on the basis of health, safety, and welfare. Issues of detriment, substantial harm, those are all pre-adjudication standards for interfering in a parent's rights. So we don't have two fit parents. We have two parents where the presumption of fitness has been rebutted. We have a child who maintains the status of neglect. And Title 30 simply doesn't apply, because Title 30 presumes presumptively fit parents. Title 30, the child has no party status. Title 30, the child doesn't have a status of neglect and abuse. And Title 30 discourages the voice of a child, whereas in juvenile court, the child's voice is required to be heard. So it's not that one is better than another. Although, Judge Orm, I have seen cases where toward the end, a judge will say, I'm going to just send it back to the district court to figure out all these other things. And also, she's arguing as if frequent modification is a good thing. And it's simply, from the child's point of view, frequent modification is not a good thing. So the standard...
Can I stop you there and ask a question? And I'm wondering if my following question might be better for father. So let me just pause there. Are you and father sharing the 15 minutes, or are you?
Yes. Yeah.
Oh.
Yes.
Okay. Let me just go and ask the question. He might get some version of it too. As I read the juvenile court's best interest determination here, it's based on a lot of things that we would normally see in a best interest determination in a custody case. How the kid's doing in school, how he's responding to step-parents, step-siblings, that kind of thing. Let's suppose that 4 years from now, all of those things change. How he's doing in school totally changes, how he's responding to step-siblings and all that changes. If mom wants to come in and change this permanent guardianship, how does she do it at that point on those grounds?
She can't. And in some ways, I'm not sure if mom's presumption of fitness ever got restored, given how limited her custody rights are. A lot of times in these cases where we restore custody to one parent, but we limit contact with another, and the case comes back into court, we look at it and we say, we really never restored the presumption of fitness to the other parent.
Okay, but that feels very problematic to me, the answer that you just gave, because if the whole basis for Judge Bazell's permanent guardianship decision, at the back end at least, is Judge Bazell's assessment of things like how child's doing in school and so forth, and now you're saying that by virtue of the fact that this is being done in the juvenile court proceeding, it can no longer be changed moving forward, no matter what happens to those very things. Whereas in the district court case, they could be changed if those things changed. Then it feels problematic to say, well, we're going to keep this in the one place where we can no longer account for changed circumstances. Why would that be the outcome that the legislature intended?
Mother can't move for modification. The child could, the father could, somebody else could, anyone can file a petition to modify in the juvenile court. Just mother cannot do that. And that's because of the restrictions of ASFA. The legislature changed that provision because ASFA, and this answers your question, Judge Orm, because the idea of a guardianship, we keep thinking in terms of the probate court, but the legislature changed the provision to mirror the provision of ASFA that said you can order a guardianship, but it has to be presumptively permanent. It has to have all these features, and that's why the legislature made those changes. Because we don't like the idea of a child who has been abused or neglected having to go back to court over and over again.
So who resolves disputes about parent time moving forward? The juvenile court or the district court?
The juvenile court can do it. A lot of times, if there is a dispute about parent time, the juvenile court may refer that to the district court. I've seen it work both ways.
What about child support moving forward? Who has that? The juvenile court or the district court?
You mean modification of it or initial?
Well, I mean, if father now has permanent guardianship, wouldn't that have some bearing on child support?
Oh, totally, totally. And so the court provides for the court to make child support orders. And so if those need to be modified, they can happen in juvenile court. And a lot of times those kind of decisions, the juvenile court will transfer it to the district court to take a look at. But the juvenile court has jurisdiction to make orders going to child support. And in fact, almost every order refers the parent to ORS to make a determination of that.
Can I pick up on one thing that you just that you said earlier, Ms. Pierce? You said it's at the determination of substantial detriment, and that inquiry is made prior to adjudication. That's not true, is it?
Yeah. Oh,
The permanency statute specifically requires that determination to be made, whether the child can be safely returned to the home.
Right. But again, those are all reasons to keep the child from the home. Those aren't reasons to intrude into the home and remove the child. And so it says you have to look at, would it be detrimental to return the child? And can the child safely return home? But ultimately, the disposition needs to be based on health, safety, and welfare. I have a whole string side about all the provisions and asked in the juvenile court that says all post-adjudication determinations have to be based on health, safety, and welfare.
But that inquiry, tell me why I'm wrong in this, that inquiry is not the same. Whether a child is going to be, there's going to be some substantial detriment to a child to be returned to the home is not the same question as which home is best for this child to live in. That is a different question.
The court had two different motions in front of it at that hearing. It had the 409 permanency hearing, and it had father's motion for custody. Now, the substantial detriment, can the child return home? That has to do with whether or not the child has to be remains from the home. But in most cases, if the answer is, yeah, it's not going to be substantially detrimental, then the response isn't, well, then here's custody to you, mom. We're all done. Usually the answer is, well, then we're going to do a gradual transition into your home. We're going to have all these protective services. We're going to do a lot of hand-holding until it is in the best interest for us to terminate jurisdiction and give you custody. But in this case, there were two different things on the table. One was father's motion for custody. The second one was the permanency hearing. And so the court totally did the right thing in this case. And I just need to remind this court that the one visit the child had to Utah, the mother sent the child's abuser to pick him up at the airport. I mean, that tells you so much about the mother's sensitivity to this child's situation. Yes.
Let me inquire about the detriment, substantial detriment, which does at least reappear in the permanency statute. I'm looking at Utah Code Section 83-409-2.
Right.
And subsection A, if reunification services are ordered, the juvenile court shall, at the permanency hearing, determine whether the minor may safely be returned to the custody of the minor's parent. And I think Ms. Adams would, in a sense, have us stop reading right there. But subsection B follows and says, apparently in this same permanency context, if the juvenile court finds by a preponderance of the evidence that return of the minor to the minor's parent would create a substantial risk of detriment to the minor's emotional well-being, the minor may not be returned to the custody of the minor's parent. So although Judge Bichelle spoke in terms of best interest, I think the upshot of some of her findings is that there is a substantial risk of detriment to the young boy's emotional well-being if he's returned to mother. So that's a subsection B exception to the usual rule of A that since it's safe there, we will return. Do I misapprehend that section?
think she said it would be substantially detrimental to do that based on mother's behavior. I think you're correct on that. And I think the distinction between this, I said before that you can't intrude into a home pre-adjudication unless you find substantial detriment. But this says substantial detriment not to return the child.
Right. We presume in subsection A that the child will be returned upon determining that that may happen safely. But in B, if we instead find a substantial risk of emotional well-being, we can choose not to do that.
Nothing there says you have to return the child. It all says here's all the reasons not to return the child. There's nothing that says that compels return of the child. And so return of the child has to be a best interest determination. It says here's the reasons not to return the child. And so I don't think the reverse is always true.
But I think you're as I took your position anyway, you're squarely within subsection B of 8834092, namely, even if in a sense the child could be safely returned, B provides an exception to that if the court finds there would be a substantial risk of detriment to the child's emotional well-being, which the judge here seems to have had in mind, given how well he was doing in Florida and how unhappy he would be to return to Utah. That posed a detriment to his emotional well-being, it seems to me.
And I think it totally harmonizes with subsection 1, because if there's going to be a substantial risk to his emotional well-being, then he can't safely return home. There's nothing safe about that situation. If you return him home and stepfather picks him up at the airport, there's nothing safe about that. So I think the judge totally was acting under her charge as a juvenile court judge to act in the child's health, safety, and well-being. So unless there's further questions, let me again emphasize, we're not talking about two fit parents. So long as the juvenile court has jurisdiction, the presumption of fitness has been rebutted, and I will give the time over to my colleague. Thank you for your attention.
Thank you. Mr. Wade, if you'll join us now.
Yep, I'm here.
The clock would suggest that you have just under 3 minutes at this point, but as you saw, we were quite generous in giving Ms. Adams considerably more time than her allotted time. So don't feel unduly constrained by the clock. In particular, if our questions take you beyond the time, that's just fine. But why don't you launch into your argument? And so long as we're being productive, you can take a little more time as appropriate.
All right, thank you. First, I agree with Mrs. Pierce when she says we are not dealing with two fit parents. I don't believe my client has ever agreed to that phrase. He has always believed and made it very well apparent to the court that he disagrees with the mother's being a fit parent. And I agree that Judge Bazell, in considering the permanency in this case, she agreed that the parents were on equal footing because they had both lost their parental presumption. But she clearly and very detailed explained why the parents are not ultimately on even ground. And I believe that her findings detail why the mother is actually not fit. And she said,
no, let me stop you there. I mean, one of the things that she finds, she says, the court, quote, did not find that the mother poses a safety risk to the child. So if the thing that got the child into the juvenile system to begin with was concerns over safety, the whooping and so forth, but then upon further evidence and reflection and the therapy and so forth, the court then says that mother does not pose a safety risk, then is what you're saying still correct, or is it not correct?
Yeah, yes, it is, because just because someone is not a safety risk to a child does not mean that they are a fit parent. And I think Judge Bazell made it very clear.
What made her unfit at that point? Once the safety concerns are resolved, what made her unfit?
Well, Judge Bazell heard evidence that when the child came into my client's care, he was socially behind, he was educationally behind, and all of that was essentially remedied in the father's care. In
How
addition,
how is that any different than what we see in any number of other post-divorce actions in a divorce case? I mean, in my somewhat limited experience doing those cases, I saw multiple cases where the parties years after the divorce were arguing about, well, the kid is suffering in school because he's in your care and I'd be a better parent in that respect. It just, one of the things that just jumped out to me from the briefing here is that almost everything that you put in your brief that Judge Bazell was considering read to me like something that you would see in an ordinary post-divorce case. And I just kept struggling with the idea, why is this in juvenile court at all if what we're arguing about is who's better in terms of things like schooling and so forth and so forth? Why does that make her unfit in some different way that puts her into a different court?
because Judge Bazell has to find and consider the best interest of the child. Why would that not be an issue that the juvenile court should look at? I think it absolutely has to be an issue the juvenile court looks at. It's mandated by statute. And I think Judge Bazell, she had essentially multiple legal questions before her. Two of them were, one, what is the best interest of the child? And two, is it detrimental to return the child to the mother? And I think she detailed very well why it's detrimental to return the child to the mother, including she found that likely the mother was likely to essentially be a horrible co-parent going forward, which would be detrimental to the child. And I can tell you, I do tons of custody cases, and it is. I mean, to put a child in the care of a parent who manipulates and uses the child as a weapon and essentially falsifies evidence about the other parent, how is that not detrimental to a child? It absolutely is.
Then why not go back to the divorce court and file a petition to modify and say, hey, the change in circumstance is that she was adjudicated, and now let's do the best interest analysis, and then say everything that you just said and have the district court do that and modify the custody provisions accordingly?
Multiple reasons. First and foremost, I agree with Judge Orm when he says that why wouldn't this be adjudicated by the juvenile court? It, quite frankly, in my experience, I do this in the juvenile court, I do this in the district court. It would make absolutely no sense to go back to the district court when all of this evidence was before Judge Bazell. She had seen this case throughout for over a year. DCFS is right there ready to testify. All the witnesses are right there. Everyone who's been involved in the case through the whole proceeding is right there. It would make no sense to then send it to the district court and deal with the delays in time that you frequently see in the district court to get the case to trial, because nothing gets done quickly in the district court. If the juvenile court were, go ahead.
Yeah, I mean, that may be true in that moment, but I suspect what Ms. Adams is going to say in response to that is, yeah, but there's a different benefit in doing it in district court, and the benefit is the one we've talked about, which is that let's suppose 3 years from now, evidence comes out the father is actually a terrible parent in terms of the education and so forth. If this is done in the district court, then mother has a ready mechanism to go in and make that modification motion. But if this is done in the juvenile court by way of a permanency or a permanent guardianship, now apparently we're stuck unless the father himself decides to bring that to the attention, or the guardian ad litem in Utah somehow figures out that that's happening in Florida. So I think Ms. Adams' response to what you just said will be the district court's better equipped to keep adjusting things if needed in the future. Why is that not the right response here?
Well, let me just say that, and I can look the statute up and tell you, but the concurrent jurisdiction statute is problematic in doing what you just said. The reason is the concurrent jurisdiction statute says that the juvenile court may modify a district court order, but that only lasts as long as the juvenile court jurisdiction is ongoing. Once that jurisdiction terminates, the jurisdiction or the prior court orders that were modified by the juvenile court are no longer modified from the district court. So, and a lot of judges, in my experience, see that as a problem, and so they feel like what the legislature has done is created essentially a few areas where a court can enter an order that survives closing the case, and one of them is permanent custody and guardianship. So it is a problem. I think the legislature needs to fix it, but the fact of the matter is our law reads what it is right now, and if the legislature, and maybe this is a problem for the legislature, they need to fix. But I absolutely do not agree with this notion that parties should be essentially left by the juvenile court without anything final and referred over to the district court to continue to fight. It's not I mean, most of these parties have little funds. So are we going to send them to the district court? And is that in the child's best interest to send to the district court for lengthy litigation that's very expensive? It's just not. Judge Orm, sorry.
We have concurrent jurisdiction here. That seems undisputed. And say what we will about what commonly happens, what might be preferable, as between the district court and the juvenile court making this determination. Did the mother at any point before Judge Bazell specifically ask that the matter be moved to the district court or object to, I mean, they argued on the merits, obviously, and she had her own requests competing with your client's requests, but did she ever object specifically to Judge Bazell entering an order of permanency on the theory that this instead was uniquely district court business and that court should take it up?
I do not believe there's anything in the record that would support that. No, not that I recall. I don't believe it. I don't believe she ever did. And that's, something she could have done, certainly, and it's something my client could have done. But like I said, it's completely inefficient to do that. It's extremely expensive. I don't believe the mother could have even afforded to go to the district court, have a custody evaluator. There's no way she could have done any of that. And like you said, a great point you made was, if you're a district court judge and you look at something like this coming to you, you're gonna say exactly what you said. I haven't seen this case in 5 years. Why wasn't this dealt with in the juvenile court? And when I've had cases where judges have had Rule 100 conferences between the district and the juvenile court, the district court always says, "Hey, you deal with this. You're right there. You've got all the evidence and all of the adjudicated facts, and you've been looking at this for a long time. You deal with this. I don't want to deal with it." So I think the issue that you're raising, Judge Tenney, is an issue for the legislature, but our law reads what it reads, and Judge Bazell did absolutely nothing wrong. I do want to point one thing out.
Sorry, before you move on that point, and feel free to do it when we're done, just to make sure that I've got your answer clear on the questions that I asked Ms. Pierce. So then if 4 years from now they want to have a fight about child support, which court do they go to?
Oh, I think the law is clear as can be, that enforcement is dealt with in the district court, and that would include issues of child support. There's nothing in the permanent, granting an order of permanent custody and guardianship is not a final order of child support. So child support can always be dealt with in the district court.
So if I've got it right, and correct me if I'm wrong, but so if I've got it right, what you're saying happens moving forward is that the district court retains the ability and is the place to go to do all the ordinary modification stuff and enforcement stuff. But when it comes to who has the kid, that's off the table now moving forward for the district court. Do I have that right?
Yes, custody and parent time. Well, I don't even think parent time is off the table. I think custody is off the table. Dad has custody. Mom's parent time can be adjusted. And so when we say that we've essentially removed the child from mom's life, that's not accurate at all. Mom has parent time. Mom has custodial rights, or she has rights to the child. She has she's a non-custodial parent, but she absolutely retains rights with respect to the child. Her parent time is, I think Judge Bazell put it as the out-of-state parent time, which is completely appropriate. She has time with the child. She has rights to that child. Dad has custody. Mom should pay child support. Child support can be adjusted. I believe mom's parent time can be adjusted by the district court. Mom's parent time can absolutely be enforced by the district court. There's nothing in the law that would support that is not an option for mother in the district court. It's just simply father has custody of the child and always will. Let me give you a scenario real quick where mother could get custody under the statutes. I have a case like this right now. If dad were to pass away and die, the statute actually does allow mother to come in and petition the court for custody of the child. And so mom is not permanently, it's unlikely, I understand. But
okay,
again,
well, let me give you a counter scenario. What if 3 years from now, dad and his current wife get divorced? So now he's single parenting, and let's just suppose that he then takes a second job and is working 75 hours a week, leaving kid to sort of be a latchkey kid on his own. Mom finds this out, and mom says, "Hey, now that that's happened, it's way better for me to be the primary custodial parent. How and to whom does she go and make that request?
She doesn't. First of all, I don't believe that would be a substantial change in circumstances under the law anyways. But second of all, I do not believe that mother has no remedy there. Right of first refusal is a common parenting provision in any district court. Mother could assert that. I believe it's also statutory. Mother could assert that. But I do not believe that she would be able to ask for custody to change, nor do I believe it would be appropriate under that circumstance either.
Okay, thank you, Mr. Waite. We appreciate the argument, and we'll hear from Ms. Adams on rebuttal.
Thank you, Your Honors. I have 4 short points. Judge Orm, first off, you've asked if mother ever requested that this case go to the district court. I have some record sites for you. She did in December 2020 at the disposition hearing. It's record site 182 she filed a document before the disposition hearing. And on record site 460, she also asked that in her oral argument before the court. And then also in June 2021, she filed another document that's on page 312 of the record asking, basically saying that this should be a custody issue that's resolved in the district court. So again, it's pages 182, 312, and 460 are the record sites for that.
Just correct me if I'm wrong, Ms. Adams, that was also the request of the attorney for the state, right? Mr. Peterson, didn't he represent the DCFS?
DCFS, yeah, DCFS agreed that the parents were fine and that the child could go anywhere. The child could go to Utah, the child could go to Florida, the child would be fine in both places. The second issue is that the GAL stated that the least restrictive means statute 80-3-204 doesn't apply after adjudication. I'm not seeing anywhere in the statutory scheme where it says that. To be very clear, parents still have rights after adjudication. Parents' rights are only limited when they're terminated. And so, her rights were not terminated here. So she still has constitutional parental rights, and there still isn't any compelling state interest to remove or to significantly restrict her parental rights here because she was considered a fit parent. And although the father and the GAL have made a lot of hay about whether parents are fit or not, fitness is a statutory determination, and you have to do some pretty bad stuff to be unfit. And I think the court recognizes here that everybody considered mother fit here. The second thing is that I think Judge Orm also asked for, or somebody was talking about father's motion for custody. What's interesting is we only have one actual motion, and it was back in August of 2020 where he asked for temporary custody for school purposes. And the court kept on putting that off and putting that off and putting that off, and then resolving that after the permanency hearing. And then finally, substantial detriment is not a best interest determination like we talked about before. The statute defines substantial detriment as not complying with the parent and family plan. Everybody agrees that happened here, that the parents complied, that mom complied, and killing another parent. And that's very clear that did not happen here. So substantial detriment is statutorily defined very differently than best interest. And as we argue in our opening brief, there just weren't findings to support us that child would be would suffer substantial detriment if returned to mother's care. Unless the court has any other questions, I ask that this court reverse.
Thank you. Ms. Pierce and Mr. Waite, will you join us back on screen? Our final little ceremony is to indicate that we will take this matter under advisement and do our best to have a decision sooner rather than later in view of the subject matter of the case and consistent with our internal operating procedures. We like to do what we can to expedite these decisions, and we'll do our best to have something to you as soon as humanly possible. We appreciate all of the arguments today very much. It's a challenging case. The arguments have been helpful to our understanding of it. And with that, we'll thank you for your time this morning. Take the matter under advisement and be in recess for about 6 minutes before taking up our next case. Thank you again.
Thank you.